The law in this area, oddly enough, of course, there are a million nuances, but there's really, for owners, for building owners, there's really one prominent case, one case that lawyers look back and will rely on to determine what a building owner's liability is. Now, what's interesting is that we have the public sector very, very well represented here today, and it's fabulous to see this kind of interest because cities and counties generally have immunity. So, and it's a very strong immunity from liability when seismic damage occurs. But you're talking to owners every day. If you aren't a building owner, the reason you're here is because you're talking to building owners every day. And this will reduce the law in this area to a very simple point, which it is. The law revolves around one case. And that case is a case, as you see down here, let me swip back, Myrick against Mestagni. You saw one picture from Matt on Paso Robles. So if you go back to the San Simeon earthquake and you think of what a wonderful, peaceful place Paso Robles was, and you may have seen the Acorn building. This is actually a picture after it's been restored. But on the morning of December 22nd, 2003, when the earthquake struck, the building, this is what the building looked like afterwards. Now, what I thought I'd do with you is since we just have really one principal case that governs the law of this area, if you'll stick with me here through these next couple of slides, we'll do what lawyers do. Lawyers read the law. This is the law. This is the case that governs this area of the law. So since it's relatively condensed, it allows me in my short segment of time here to actually cover the entirety of the law, the important parts of this case, and do with me what lawyers do, just read through the case with me. And what you'll see is this is a description. The description I have up here is the factual description of what happened on the morning of the earthquake. And the reason the courts lay that out is because the law is going to be applied to the facts. And the defenses that owners try to assert will be tested against those facts, whether they work or not. So, this is the story, the very, very sad story of young Jennifer Myrick and Marilyn Frost Zafuto, who were at the site, were in the building, and tried, as you can see, when the earthquake began, they tried to flee the building, but they couldn't do so. Or they did. They got outside, and the building collapsed on and killed both of them. So from that, you can imagine, the damage was significant. Litigation followed, and who I know Ali knows Joel Castro well, the plaintiff's lawyer who tried this case, and this has been the one person who's come through. I've highlighted the important points that he argued and that were accepted by the court. So this is a little more on the background. This gives you some sense of the time span that the owner had to assess what to do about the building. So the city's doing what it needs to do back in 1989, and so the city actually sends notice to the building in 1989, and then as part of the mitigation program, the city enacts its ordinance, but then extends the ordinance to compliance has to be achieved by 2018. Now, I think everybody has a good sense of if the law is that you need to be in compliance by the end of 2018, on January 1, 2019, if you're not in compliance, you've got a problem, and if the earthquake occurs that morning, the standard of negligence is going to be very easy to assess because you're not in compliance with the law. But the question is, what do you do up until that time? And what is the test? What obligation? If you're talking to a business owner, if you're talking to someone who owns their building who's within your city, if you're talking to your own client to assess these issues, the question is, what is the duty of the person who owns the building? So there you see what the city did, and now here's what happens. You've now got a consultant who's brought in, but nonetheless, the retrofitting is not complete. So now, look at the time span. All the way back into October, the city was working on this years before, and now in 1998, there's even a consultant hired who can do the work, who can create the plan to do the work, and nonetheless the work doesn't get done. So the question is, those are the facts. So that's what courts do. They look at the facts and then they apply the law to the facts. So what's the basic rule? We all know, everything we do, we have to conduct ourselves in a way so that we take reasonable steps not to cause harm to other people. We know that that's everything we do, whether it's my pushing the table back here or anything else. We have a duty not to harm other people or to bring harm to them. That's basic, but that test of ordinary care applies in this area, and that's what everything comes down to. The test is whether an owner has acted as a reasonable person in view of the probability of injury. I was hoping Matt would answer this question, and he did. What's the probability, the likelihood that there will be a seismic event? We just saw his chart. You as an owner, if you're a building owner, you know that that's a very high probability. There's a very good chance that an event could occur that will cause serious damage to your building, and the result may be harm to human life. So, if that's the rule, what's the defense? What did the owner in this case argue? So here, the owner argues, well, I complied with the statute. The city extended the date for my compliance all the way out to 2018. So, here we are, we're at 2003. I got a long time to go before I have to worry about this. Well, so now you see the rule. Now we're coming up to what the law is and what the standard is. The fact that the city has required compliance by 2018 doesn't mean you're okay finishing on December 31st, 2018. What it means is if you try to use statutory compliance as a defense, you see right here where the court says that, it sets a minimum standard of conduct. A minimum does not preclude a finding that a reasonable person would have taken additional precautions. Now, who is going to be making this decision? A jury is going to be making that decision. So right now, as you sit here, you have all these resources around you. You have all these people who can help you today to make a difference in your. You have all these things that you can do. You have engineers. You have the contractors. You have all these folks who can help. But when you hit the stage of litigation, everything is looking backwards. Not what can you do, what did you do? And what did you know? And that gets back to the early slide where I had what's the paradigm of liability. So you know there's a minimum that you need to do, and that's finished by 2018. But so is mere compliance enough? The court says no. Mere compliance is not enough. You have a duty as a business owner to do more than that. And so how does everything get assessed? The argument by the owner was that the fact that there was legislation means that whatever the state legislature, whatever the city, whatever the county decided, that's a legislative determination of what's reasonable. But as you just saw, the Court of Appeal rejected that. That's maybe a minimum. That's not enough. And so one of the interesting pieces of evidence that Joe used to mention when he talked about this was that the elevator for the building was commissioned. That was actually more than the retrofit that was designed for the building. It was less than that. So if you are sitting in a chair and a lawyer is asking you, what did you do and what was it reasonable for you to have done, you can be sure that you're going to be answering questions about what you did do with the financial resources you had available. Did you decide to put in an elevator? Did you decide to do a cosmetic change to the building that made it much more leasable? Maybe you were able to elevate the rent a little bit. Did you have the borrowing capacity to make the changes that you needed to make? Those are the questions the building owner is going to be facing. And everything comes down to the point, which this was not coordinated, but you finished on a perfect point, Matt, which is these laws exist not for the benefit of a property owner. These laws exist for public safety. That's the purpose of all of these points. It's public safety. So I'm going to skip over issues that might involve it. So that tenants. So we're now down to the issue is what would a jury deciding what was reasonable for you to have done? If you're talking, Mike, to the people in your city, the owners in your city, because you got lots of folks who have buildings that are in one way or another implicated in these, and knowing what the city has done, what do you say, and what do the owners, what considerations do the owners have? Are the owners going to be sitting in front of a jury answering questions? What have you known? What did you do? What could you have done? Who did you talk to? If you didn't get anything done in time, what could you have done to have made that happen? And above all, what else could you have done? And the way that these questions get answered determine whether liability will be imposed, and that will be not the decision, in all likelihood, of the judge, not the decision of the first responders, not the decision of the governor or the mayor or anybody else. It will be 12 people sitting in the jury box who decide, were you reasonable? This test of reasonableness. Did you do what was reasonable to find out what the conditions were? And once you knew them, what did you do to remedy those conditions? And it will be a jury that decides. So I don't have anything else, but thank you.
What was the outcome?
Award of $2 million for the plaintiffs, and it was upheld on appeal, and so it stood.
Were there any questions for Madison?
Good, because the real question should be these questions. Think about these. Don't worry about asking me anything. Ask the people you work with these questions.
Thank you, Madison. Let's give him a hand.